Hello, my name is Mark Watts. I'm a partner here at Bristows in the IT and data protection group. Today I'm going to talk to you a little bit about cloud computing and some of the data privacy risks that arise when organizations are thinking about putting their information up into the cloud. It's not going to describe in great detail what cloud computing is. That's fairly well understood. Nor is it really going to get into some of the detail of the issues. That may be something that we follow up with on a subsequent video. It's really going to focus on some of the high-level data privacy risks and look in particular at some of the risks associated with international data transfers. So for the purposes of this video, just think of cloud computing as using internet-based technologies to deliver computing power, whether that's storage or functionality as in a software as a service situation or whatever it might be. Just think of an organization that instead of hosting its data and its systems itself, it's proposing to give them over to a third-party cloud provider which will store it on their systems wherever they may be and provide access to that data and that IT functionality or storage or whatever it is via the internet. So what are the headline data privacy risks? Well, this is something that's received the attention of the Article 29 Working Party. That's the group of European data protection authorities collectively writing and issuing opinions on data protection issues of the day, including cloud computing, amongst others. This is one they looked at in their paper 196 in July of 2012. And in very broad, high-level terms, the two sort of umbrella risks that they identified for controllers or customers proposing to put their personal data into the cloud was that there can be a lack of control, and we'll talk about that a little bit more in a moment, but also a lack of transparency, which we'll also get into. Now, in terms of the lack of control, there's potentially many aspects to this, several of which were identified by Article 29. But what they're really talking about is that by not having your data yourself anymore as a customer and handing it over to a third party and putting it onto usually international IT systems, potentially on the other side of the world, there is the possibility in the view of the regulators that you lose control over things like when your data is available, how it's protected, so what security is in place, and also the circumstances when you're able to take your data and migrate it from one provider to another provider, the so-called data portability aspect. And then they went on to talk about various more specific aspects of this lack of control. So one of them, for example, touching on the data portability piece, was that if you put your data into the hands of a cloud provider and that provider uses their own proprietary technology in order to provide the service involving the data processing, whatever it is, then you may be locked in potentially, because moving your data, switching it to a different cloud provider, either during the term of the arrangement or at the end, may be difficult because the proprietary technology either impacts on the format of the data or simply just makes it more difficult to switch to another provider. One of the other aspects of the lack of control compared to if you would have the information hosted and processed in-house, as you may traditionally have done, is that you're handing the data over to a cloud provider who will have lots and lots of customers and potentially lots of competing priorities and interests, and you may be just one of a large number of customers whose data is in the cloud, and there may be the possibility that the provider's priorities and their their interests conflict with your own, as opposed to, let's say, the situation where it's your data, you're hosting it yourself, and you have the only priorities you need to concern yourself with are your own, frankly. Now, that isn't to say that putting it into an environment where there's lots of other customers' data is necessarily bad. That's not the point that Article 29 are making, and indeed they go on to say, well, you could get a significant upgrade by using a cloud provider in terms of data security, because it would potentially open up access to all sorts of cutting edge and state-of-the-art technologies and data security methodologies that you as a single relatively small organization may simply not be able to afford. So they're not saying it's a bad thing, they're just highlighting that there is a category of risk here that just needs to be worked through. One of the other risks that's been identified, and one that's particularly newsworthy at the moment, is the whole issue of law enforcement requests. So this sometimes gets wrapped up into a discussion about the USA Patriot Act, and so the idea that if you use a US cloud provider that's subject to the jurisdiction of US law enforcement bodies, then there may be circumstances where your data, that is you as a customer, your data in the hands of that provider, may be made available or be required to be made available to the US authorities. Now, for the most part, a number of these concerns have been overblown, frankly, and the idea that because of the Patriot Act, US authorities get access to everything isn't quite right, and equally nor is it right to suggest that there aren't equivalent powers and requirements under European law. So it's a much more nuanced and complex conversation and issue than is normally really given credit to. And the other aspect, of course, is that most recently we've had the whole issue about PRISM and law enforcement access. And what's come out of that is that it is, again, just underlines the complexity of the situation, and it's become clear that actually there's an awful lot of situations where there may be law enforcement access to data, and it's really not as simple as US providers problem, EU providers good news. It really isn't like that at all, in my opinion. One of the other risks, this lack of control category of risk that Article 29 talk about, is what they call the lack of intervenability, which apparently is a word. And what they're referring to there is the idea that you hand your data over into this much more complex environment where there could be lots and lots of data centers involved. There could be many layers of provider. So if it's a software as a service type cloud computing offering, then underneath that there may be some infrastructure as a service. There could be lots of players and subcontractors and all the rest of it involved. And in that complex cloud ecosystem, if something goes wrong, if you're not happy with security or whatever it may be, then the opportunity for you as a customer to get involved and to somehow influence the way in which your data is being processed may be, and I only say may be more limited than would otherwise be the case if you hosted that data internally yourself, for example. There are various other risks one could get into under this category of the arguably lack of control. The other category though that I wanted to talk about was, in the view of the Article 29 Working Party, that there is the risk of a lack of transparency. And this may or may not be the case. I think it very much depends. It depends on who the cloud provider is, what the precise situation may be. What they're getting at here is that, again, it goes to this point about the complexity of the arrangement. So there's potentially lots of providers. The service that the customer is taking could itself be some aggregation of other services provided by cloud providers. There could be various subcontracting arrangements, there could be data centers all over the place. It may actually just be very difficult, if not impossible, for a customer, even a customer trying to do a significant amount of diligence, to be able to work out all the different sort of pieces in the jigsaw so as to be able to accurately assess any risk regarding how their data is being handled. If you don't know where it is and you don't know who's handling it and you don't really know what they're doing with it, then it's kind of difficult to nail down where the risk may be and certainly what you can do about it. So that's one element of the complexity. The other element of this sort of lack of transparency because of the complexity is quite a legal point. It has to do with two bits of applicable law, if you like. There's the question of, what law applies? So we'll get into some of that when we talk about EU data protection law and when it applies. But there's also I mentioned law enforcement. Well, when do the laws of a particular country and its law enforcement powers, when do they apply? And And often that has to do with where the data center is, where the data is being processed, because, again, roughly speaking, if the data is physically in a particular country, then it's pretty likely that law enforcement authorities in that country, assuming they have the powers, will be able to exercise jurisdiction on that data and use those powers to access it. So where the data is can matter sometimes in terms of who else may be able to get hold of it. And then the other aspect of this is that, as many people know, there are some significant restrictions on transferring data out of certain countries, the EU being the most high profile of those. Any legal restriction on data moving from, say, the EU to the United States or India or wherever it may be can present a significant challenge where the whole delivery model of the cloud provider is based on using international infrastructure and moving data from one data center to another in the interests of efficiencies or whatever it might be. That can introduce what you might call a geographic complexity. And if you try and take that complexity as a customer, that can present some challenges in terms of, firstly, your understanding, but secondly, how you then communicate it to the individuals, your own customers, that you're processing data about. Now, this manifests itself in various different ways. What we see sometimes is situations where it's simply not possible, even despite everybody's sort of best efforts, to say precisely which third parties, if you include subcontractors, may be involved in any given cloud processing service. The list is too long. The list changes too often. It's just very, very difficult. It can also be difficult from a geographic point of view to say where data is at any point in time. So you'd hope that a cloud provider would be able to at least know where its data centers are. They may not want to tell you for security reasons, but they at least know where they are. But again, what may be much more difficult for them, just from a practical point of view, is being able to say from where people may have access to your data. So there could be data centers in 5 countries, but there may be teams providing elements of the service or with administrator access or whatever it is in lots of other places that becomes very difficult to pin down in terms of the geographic distribution of the data. So that's a snapshot of the risks that seem to be troubling at least the data protection authorities to some extent. And now we'll move on to how some of the fairly well understood data protection legal concepts, things like controllers and processors, how they map to this world of cloud computing. So now if we look at how some of the familiar definitions under European data protection law apply to cloud computing, we're really talking about controllers and processors. So just by way of a very brief recap, controller, think of that as the organization that often but not always owns the data. They're the organization, if you like, that's making all the decisions in terms of what data is collected, what's done with it, what's the purpose of the data processing. So that's usually the customer in a cloud computing situation. That is, the organization that's got the data and is deciding to put it into the cloud, they would almost invariably be a data controller. The real question, though, is, well, what's the cloud provider? Are they a processor? And the processor, of course, is just the entity that merely processes the data on behalf of the controller. It's just doing as it's instructed to do by the controller. Or could the cloud provider in certain situations itself be a controller or perhaps a joint controller? Both are possible. Most of the time, the cloud computing provider will be a processor. And this is significant. It's significant for the controller because it means there are certain security requirements and contractual requirements that it needs to fulfill when it's engaging the cloud computing provider. It's significant, perhaps very significant, to the cloud provider because by being a processor under applicable data protection law as opposed to a controller, it means that you have fewer, and in some cases zero, direct statutory obligations under the law. To the extent you do, it tends to be an obligation to implement appropriate data security measures. So what are the circumstances where the cloud provider may be a controller? Well, the most obvious one is, and we see this sometimes, particularly in very standard, sort of fairly commoditized cloud services. But if the cloud provider is taking the data from its customer, it's processing it to provide the services to its customer, but also it uses the data in some other way for its own purposes. So for example, if it's got 100 customers, if it does processing on the data of all of those 100 customers in order to do some kind of analytics, extract some sort of meaningful conclusions or whatever it might be, if it's doing that and it's doing it in such a way that the data isn't anonymous, then one would typically say it's using that data for another purpose that it determined, and that would typically be enough to tip it over into being a data controller. The other situation that's a bit more complicated, where a provider can tip over into being a controller, is not where it's determining the purposes of what's done with the data. Perhaps it doesn't want to use the data for its own purposes at all. But if it's making such significant decisions about how the data is processed, then, in other words, if it's making decisions about what's sometimes referred to as the essential means, so really important aspects of the processing, then that can be sufficient to tip the provider into being a processor. So for example, there have been situations where a cloud provider has unilaterally decided we'll move our data center from this country to another country, and perhaps as a result of that move to another country, it's exposed the data to a greater risk of, say, law enforcement access or some other form of access. By making that decision, at least some data protection authorities would say that the provider has exercised sufficient control over these essential means, or how the processing is done, to tip it over into being a data controller, which means it has its own obligations under the law and it has a much greater compliance burden, if you like, in relation to that data. So in summary, most of the time cloud provider is a processor, but there can be situations where they're either a controller or a joint controller. Now the other question legally is, well, so what country's law applies? And as I mentioned in the earlier part of the video, there's two elements to this. There's what is the applicable law generally, and that can often be determined by where the data center is. And so I mentioned law enforcement access. That's a good example, if you like, that depending on where the data center is, there may be local laws, whether they're law enforcement or antitrust authorities or simply, subpoenas from a court or whatever it might be. There may be ways under that particular jurisdiction whereby somebody else may be able to gain access to the data in a particular situation. So that's one aspect of applicable law. The other aspect is what data protection law applies. And without getting into sort of all the ins and outs of it, essentially the way this works is that in Europe at least, if as a customer using cloud services, you are established, which usually means being incorporated or having some sort of stable operation in a particular country, then the data protection laws of that country will apply. And then it doesn't matter where the data processing takes place, because it's linked to where the controller is. And if the data is processed by a cloud provider in the US or India or anywhere else in the world, it doesn't matter, the law of that EU country of establishment would continue to apply. Now the other situation is where maybe there isn't an establishment in the EU. There's no subsidiary, there's no branch office or anything like that. What are the circumstances where EU data protection law may nevertheless apply? And then it all becomes about where is the equipment, and essentially if the data center being used to process the data on behalf of that controller based outside of Europe, if the data center is located in the EU, then EU data protection law will nevertheless apply. So that's a bit of a summary, if you like, on applicable law. One of the other interesting questions that arises sometimes in a cloud computing situation, perhaps more in an infrastructure as a service situation than a software as a service situation, is, well, is there personal data involved at all? And what this is getting at is, I mean, of course, most of the time there is. It depends on what the application or service is doing, but oftentimes the service will involve encrypted data. And so the question arises, if you have data that is ultimately personal data in Europe, but before it passes to, say, the US and into the hands of the cloud provider, it's encrypted, and let's say it's got some decent level of encryption on it, and the encryption key never goes to the US and never can and never will, then is it possible to treat that data in the hands of the cloud provider as being anonymous? And does that relieve you from some of the obligations arising from this situation? And in particular, does it mean that you can transfer the data out of Europe because you're not transferring personal data out of Europe? And the short answer on that is that it is certainly possible to look at things that way. And we see in conversations with data protection authorities a little bit of a spread of views, some disagreement. The situations are often so complicated that it can be a little bit difficult to pin people down. But on the whole, that is a line of argument that is worth exploring. It does crucially depend on the level of security and also the lack of likelihood that the cloud provider would ever be able to lay their hands on the encryption key. But there's even support for this line of argument under the EU-US Safe Harbour, which has obviously been around for a while, but contains a specific FAQ dealing with what is called coded data. Now, that was written for the most part to deal with the handling of key coded data in the hands of pharmaceutical companies involved in clinical trials, but everything about it would apply with equal force to a form of coding that you might consider to be encryption. So there's a strong analogy there that would strongly suggest that the data protection authorities in Europe ought to be sympathetic to that way of looking at things and saying that, of course, it will still be personal data in the hands of the customer/controller, but at least in the hands of the provider, it may well not be. And then finally, one of the other issues that sometimes arises is, well, is the provider processing? So whether it's personal data or not, we've talked about, is what the cloud provider is doing to the data processing? And that will depend on the nature of the service, obviously, but if they're hosting it, then most people would say yes, they would be considered as processing the data. But there comes a point where the services provided by the particular cloud provider are so remote or so distant from the data that it may be possible to argue, or at least consider saying, well, they're not really processing it, and that means we as a controller and a customer don't have to worry about some of the complexity that we otherwise would, such as putting in place lots of model agreements with that particular provider or whatever it is. Another example might be that we sometimes see is someone who's involved in the overall cloud services ecosystem, but perhaps only by providing one fairly small element of the service. So an element of the service that's far removed from the data. So if you think about, say, a company that runs a co-location facility, then they may be providing physical premises, obviously, and they may have a role in providing the physical security. Maybe there's a role in providing the telecoms in and out of the location, but other than that, they have no knowledge, they have no sense of what, if any, personal data may be being processed by their customers within that co-location facility. And we see a range of views as to, or range of circumstances as to whether people insist upon even that co-location provider being considered a data processor. And it's difficult, and often we find the resolution of that is more found in the commercials of the deal and the overall complexity and the leverage of the parties. But one argument that would weigh in favour of treating the provider of that sort of physical premises as a processor would be, well, to the extent what they are doing has a role in providing physical security, so if they're responsible for manning reception, badge reader access, locking doors, access controls, and all the sort of general physical perimeter stuff, then without that, the data is potentially exposed. And that would be, I think, a fairly strong argument for saying that they need to be considered as a processor, because actually what they're providing does have a significant role in terms of the protection of the data. Now I'd like to say a few words about the issue of data transfers in a cloud computing situation, and how the various solutions, if you can call them solutions, to this export ban, if you will, on personal data leaving Europe, how they may be used in a cloud computing situation. Now this is incredibly complicated potentially when you think about a large enterprise customer with hundreds potentially of subsidiaries butting up against a cloud provider with potentially itself lots of subcontractors and subsidiaries and data centers and data going all over the world. I think the first thing to appreciate is that achieving a very, very, very good level of compliance is incredibly difficult. And what we tend to see is organizations approaching it a little bit more sensibly, taking a risk-based approach and trying to tailor their solution to the level of risk involved, potentially. At least that's what they should be doing. So one of the things that's often put out there as a solution or as something that's extremely desirable is the idea of having an EU-based data center. And that does away with a significant amount of data transfers to the US or wherever it may be if the data center were located outside of Europe. And sometimes people seem to think about this as just being the answer to all their prayers. Well, it can be helpful. There's no denying that it can be helpful. The data maybe is a bit closer if you're an EU-based customer. That gives you some reassurance. You maybe have less concerns about things like the Patriot Act, which I said earlier, largely overblown, but nevertheless, it can still be helpful. And also in some sectors, whether it's the finance sector or the healthcare sector, where the data may be a little bit more sensitive, again, having an EU-based data center can provide some additional reassurance if you're concerned about these sorts of things. Other things to think about, though, are things like this. While the data center may be in Europe, and so the data is being hosted in Europe, the restrictions are all about data transfers. And so if you're really going to rely on the fact that there's no data transfers, then you would need to have conversations with your provider about, well, so where are your support teams? Where are your staff who may be accessing this EU data center? Because if they're based outside the EU, then that would nevertheless be considered a data transfer. And obviously the amount of data potentially being transferred through a remote access arrangement is going to be less than if the data center is wholesale located outside of the EU. But nevertheless, there's potentially some risk there. And if you're looking for a super compliant system, then there's some other things to work through. As there would be with thinking about where the backup or disaster recovery elements of the system are located. Are they also in the EU, or could they be somewhere else? If they're somewhere else, then you still have a situation where your entire data set is located outside of the EU, which, if that's what you're trying to avoid, would be undermined by that sort of arrangement. And then the other thing that we very often see is that whereas cloud providers are happy to offer an EU-based solution, sometimes at an additional cost, sometimes not, it just depends. When we look at the contracts around that sort of situation, often the provider will reserve the right to move that data center in certain situations. They may accept an obligation to at least inform the customer, but informing a customer is different to getting the customer's prior consent or agreement or whatever may be necessary. So there's just a few things to watch out there. An EU-based data center may be helpful, but equally it may just cost you more and not solve all the problems you're trying to solve. The other potential solution that's relied on by a number of cloud providers is the EU-US safe harbour. This can be a very good solution. It can cut down the amount of regulatory paperwork and filings that the customer in Europe has to go through because, and without getting too legal about it, because the data transfers to the cloud provider would be under the banner of adequacy as opposed to adequate safeguards. In other words, it's a different piece of the law. It comes with a little bit less paperwork. Now, having said that, we often see some of our clients saying, well, the provider's in safe harbour, so that's it, I don't need to do anything. And that's not right. Even if the provider is in safe harbour, you still need to have a contract. You need to have a data processing agreement with them because you still have a controller processor relationship. That's something that's even set out in safe harbour itself, so that couldn't be clearer. What we've seen on the EU side amongst the data protection authorities is a slightly grudging acceptance of the use of safe harbour in this situation, but a list of additional contractual requirements that must be put in place between the customer / controller and the cloud provider or processor in that situation. And most recently, just in the last sort of few days or so, what we've seen is some of the data protection authorities, and some of this is coming out of Germany, really calling into question the suitability of safe harbour for some of these cloud computing situations. And that seems to have caught the eye of the European Commission, so it may be that in the not too distant future we find ourselves having to revisit the use of safe harbour as a solution in these situations. But for the time being, personally I think it can be a good option. Finally, the other thing to watch out for is that if the cloud environment is not solely focused on the US, but there may be data transfers here, there and everywhere, or what's called onward transfers under safe harbour, then it's necessary to think about how the cloud provider is dealing with those. It's all doable, but a few things need to be thought through there. Now the other available solution, and by the way, I'm not proposing to talk about binding corporate rules for processors, although that's something that is theoretically available. It's too early days to really talk about it in what's essentially an introductory discussion on data transfers. But the other one that's available is EU model clauses. So there's different flavours, 3 different flavours, or 2.5 if you like. There's the controller ones, 2 of those. There's the controller processor ones, of which there is now only 1 set. And essentially the customer or controller would seek contractually to put in place EU-like protection for the data that it passes to the cloud provider using these EU controller processor clauses. It can be a good solution. It's very much a paperwork solution, by which I mean we sometimes see it used merely as a means of ticking boxes, and we would discourage that. It should be thought about as a real contractual document, both by the controller, they are assuming obligations under it, but also by the provider or processor, they are assuming proper legal enforceable obligations under it, and so it's something to be taken a bit more seriously. Now what we often see, and where things can get rather complicated, is that the way the model clauses for controllers and processors have been written is very much a 2-party arrangement. So controller in Europe, processor, say, in the United States. The reality, though, of many cloud computing situations is that that controller may be one of many controllers based in Europe. There could be hundreds or even thousands of organizations all putting their own data they control into the cloud. And equally on the provider side, there may be one lead provider entity, but the service will be provided with the support of lots and lots of other subsidiaries, potentially from lots of other data centers, maybe in different countries, and also potentially with an whole army of subcontractors and third parties also involved in providing the services. So getting that fit between the paperwork, the controller processor clauses, and the complexity of the 2 groups and the complexity of the international data transfers can be very, very difficult. And what we generally advise organizations to look at is essentially to take a risk-based approach, because trying to cover each and every permutation of data transfer is extremely difficult. No sooner have you done it than it will probably change. And it also can create a slightly false sense of data protection, because you spend all this time working on the paperwork, whereas actually that isn't doing a great deal to protect the data anymore. It's merely satisfying certain regulatory requirements. So I'll leave it there. That was really intended just as a summary of the overall risks associated with cloud computing, and in particular some of the risks associated with data transfers, and just a flavour of some of the options available in order to overcome those. I hope you found that interesting and helpful. Thank you very much for listening.